We live in one of the world's most culturally diverse countries. With people in Australian households speaking over 300 languages, we regularly see people come before the courts who are not proficient in English, as well as those who use Auslan or another sign language. As a judicial officer, it's your role to ensure everyone has equal access to justice and procedural fairness. If it's a criminal case, it's also your responsibility to determine fitness to plead. And to do that effectively often means assessing someone's capacity to communicate in court and if an interpreter is needed.
This film will cover the following 4 steps to assess if an interpreter is needed, including checking with the party or the witness if they want an interpreter, assessing their speaking ability, assessing their understanding of some terms they will hear in court or the tribunal, and assessing their overall communication capacity.
First, ask the party or witness what language they prefer to speak. If it's not English, an interpreter may be necessary. Suggest this sensitively because they might not understand how an interpreter works, or might have had a negative experience with one in the past. They may feel embarrassed that you don't think their English is good enough, or they just don't want other people knowing their business. Simply asking, "Do you understand?" is not an effective way to decide whether to work with an interpreter. A nod of the head or even saying yes in some cultures may not always indicate that the person understands. Even if they don't request an interpreter, it may still be necessary for you to assess their speaking ability. The specialist language used in the courtroom and pressures of appearing in an intimidating and unfamiliar environment may mean that people overestimate their fluency in English in this context. Start by telling the person that you'll be asking them some questions to check that they can give you the information you need in English. Ask questions that don't require a yes or no answer, such as, "Tell me about any jobs or training that you have had," or "What do you think about living in this town or city?" Asking questions like this can help reduce nerves, as well as providing an opportunity for interaction. If the person is not giving full sentence length responses, try other questions to see if they can continue a conversation. If their answers are still incomplete, that's a sign that you should ask for an interpreter. If you're happy with the responses, the next step is to assess the understanding of terms that could be used in the court or the tribunal. Remember, just because someone can speak about everyday topics in English doesn't mean they have the proficiency to communicate fully about complex and stressful topics. Using 2 medium-length sentences in the style that might be used in the proceedings, ask the person to explain them after you have said them. For instance, when a person is guilty, it means that a judge or jury decided that they broke the law. In court, guilty has a different meaning from when people use the word outside of court. A judge can say that a defendant is guilty, even when the defendant does not feel guilty. The final stage is assessing their overall capacity to communicate. Some things to consider in this assessment are, does the person respond clearly? Do they only speak in short sentences or give one-word answers? Do they often respond inappropriately, for example, saying yes to what or where questions? Is the person incoherent, even when their words and grammar are clear? Do they contradict themselves and appear unaware of their contradictions? Are they using their own words, or do they simply repeat your words or phrases? Are they using English grammatically? For example, they might mix up pronouns, he instead of she, or misuse the past tense. Do you continuously need to restate and simplify your wording? It's important to remember that there are other factors that can affect a person's ability to understand court proceedings, including hearing, language, and cognitive impairments, acquired brain injury, and mental illness. Some people who have a hearing or other impairment may also speak a language other than English or sign language other than Auslan, which means that you need to take both factors into account when assessing need and arranging the interpreter. These steps will help you to assess if the court or tribunal needs an interpreter for a party or witness to participate in the proceedings. Check with the party or the witness if they want an interpreter. Assess their speaking ability using open-ended questions. Assess their understanding of some terms they will hear in court or the tribunal. And assess their overall communication capacity.